The theme for today's 2024 World Human Rights Day is Our Rights, Our Future Right Now. This is the theme decided by the United Nations. Why are human rights so important? Is the matter of concern even today, as Pratibha ma'am rightly said so. What are basically human rights? Let me also tell you that these are defined by our own Indian legislation, the Protection of Human Rights Act 1993, defined under Section 2, subclause D, 1D. These are the rights relating life, liberty, equality, and dignity of an individual, guaranteed by the Indian Constitution and embodied in the international covenants enforceable in India. The two covenants, which I'm just going to speak right now after some time. When we speak of human rights, let me tell you that it's a matter of concern. In fact, yesterday itself, I signed a petition supporting the mass genocide that's taken place in Bangladesh, where there is a mass level genocide, inflicted as against the Hindus in Bangladesh. So it's been a day-to-day happening where human rights are grossly violated all across the country. Let's be concerned about India and let's focus from an Indian perspective. It's been 76 years, as Pratibha ma'am just mentioned, that the UN General Assembly adopted the Universal Declaration of Human Rights 1948. And it's been 76th anniversary or 76th year since the adoption of the Universal Declaration of Human Rights 1948. It's been more than 7 decades since India achieved its independence. It's been more than 7 decades since the Constitution of India was put in its place. But today, if I have to ask a question to myself, or if I have to ask a question to anyone across India, that how independent, humane, and dignified life do we live, I'm sure the daily newspaper reports is an answer in itself. So, be it international terrorism, be it international trafficking, be it communal conflicts, be it religious rivalries, be it attacks on minorities, custodial atrocities, which we read in the newspaper almost every day, human beings who are victims of man-made disasters, they are victims of famine, they are victims of various other types of tortures which are inflicted as against them. There are human rights violations by none other than the politicians, the ministers, and the law enforcement personnel as such. All these news reports are an apparent answer in itself. Why are human rights so very important, though we have entered or though we have completed more than 7 decades of Indian independence, and though we have the best of best constitution, the world's largest and the best constitution across the globe. If I speak, or if I just think of the custodial atrocities, what reminds me is an incident that had happened long back in India, was when the great Sikandar captured and conquered and captured King Puru. He imprisoned the king and he asked the king, how should I behave with you? And very proudly did the King Puru say, well, I still continue to be a king and therefore behave with me like a king only. Introspecting myself, does the same position continue today? More often than yes, the answer would be no. Because we have been reading in the newspaper every day the types of violations that take place as against the Dalits, as against the indigenous people, as against children, as against women. And there are huge, I'm sure that's so, even you should be having an LLM program where there are series of marginalized groups, or whom we term as vulnerable sections of the society, and their human rights grossly violated day to day. So if this be so, I'm sure as citizens of India, it's a matter of concern for all of us. And therefore, it's high time. And as aptly the theme says, the United Nations theme says, our rights, our future. And right now, it's a matter where which we need to focus our attention right now. Can we tell or can we call India as a civilized nation? And how are we going to gauge the civilization of a country? When the quality of a nation's civilization can largely be measured by the respect a nation state gives to its citizen towards protection and promotion of human rights and the method it uses for enforcement of these rights as such. The Constitution of India, within its broad four compartments, the preamble, the fundamental rights, the directive principles of state policy, and the fundamental duties, expresses its commitment towards protection and promotion of human rights. And a free and independent judiciary has also played a prominent role in interpreting the various legal provisions in the context of human rights. So how we have known, few days back we celebrated the Constitution Day, and I just when I was invited as a resource person at a place where I just said that how long did it take to, for the Constituent Assembly debates? It took nearly 2 years, 11 months and 17 days, approximately 18 days to draft out the Indian Constitution. The drafting committee of the Indian Constitution were also highly inspired by the goals and dream of achieving and securing human rights for all. And therefore, this a close scrutiny of these two documents, one an international document and one the Indian Constitution. An international document, as Pratibha ma'am rightly mentioned, the Universal Declaration of Human Rights of 1948. And within 2 years thereafter, the Indian Constitution was put in its place on the 26th of January 1950. These two documents reveal a lot of identity. The preamble of the Universal Declaration states that whereas recognition of inherent right of equal and inalienable rights of the entire human family is the foundation of justice, peace, and freedom in the world. And the very first article of the UDHR begins with the words, all human beings are born free and equal in dignity and rights. They are endowed with reasons and conscience, and therefore they should act with one another in the spirit of brotherhood. Today, when we are marking the world 10th of December as the World Human Rights Day, it strikes me of what were the debates even when the UDHR was drafted. And Eleanor Roosevelt was the chairperson of the drafting committee of the UDHR, and there was a stiff opposition with regard to user of this word brotherhood, which according to many was a male centric word. So when all human beings born free and equal in dignity and rights, they are endowed with reasons and conscience and therefore should act towards one another in the spirit of brotherhood. So why brotherhood and why not sisterhood was the matter of concern then. But the basic spirit behind using this word, you find often these words even within the articles of the Indian Constitution where the user of the word is his. But the intention behind these words is that it's applicable both to a male and a female. Well, just as we have two set of rights within the Indian Constitution, the Fundamental Rights Part 3 of the Constitution and the Directive Principles of State Policy Part 4 of the Constitution, identically we have two categories of rights under the UDHR, and that's the civil and political rights and the economic, social, and cultural rights. The civil and political rights are almost synonymous to the fundamental rights within the Indian Constitution, And the economic, social, and cultural rights within the UDHR are almost the same as what we have in the directive principles of state policy. Therefore, the impression is as if the drafting committee of the Indian Constitution have picked up the rights from the UDHR and they have imbibed it within the Indian Constitution. Well, one set of rights are called as negative rights or the liberty oriented rights, and the second set of rights are called as the positive rights or what we call as the security oriented rights as such. To what extent have we realized this, and why are they termed as negative rights? The reason is it restrains a state from encroaching upon man's action. That means negative rights. Don't do this, don't do this, don't do this, in order to ensure that the human rights of the individuals are protected. The second set of rights, which are called as positive rights or security oriented rights, and therefore, no wonder we say India is a welfare state as such. Those are positive rights because it's thrusting an obligation on the state. Do this, do this, do this for the welfare of your people. Now, to what extent have we realized these rights is a matter we need to just check, introspect, dissect, and research into as to what extent have we realized. And therefore, I'm very glad that the MP Law College has selected a theme from principles to practice, and I'm just going to narrate few of the cases as to how the apex court or how the judiciary has interpreted these rights as such. Let me just enumerate few of the rights which fall under the civil or political rights very quickly, because I am sure as human rights students, all of us know that there are 30 articles within UDHR, and the ones which are civil and political rights are the right to life, liberty, and security of a person. There's a right against slavery and servitude. There's a right against torture and other cruel or inhuman, degrading treatment or punishment. There's a protection from arbitrary arrest and detention. There's a right to compensation in case of unlawful arrest or detention. There's a presumption of innocence, which we do have within our Indian domestic or municipal laws as well, that every person is presumed to be innocent till held guilty by competent court of law. There's protection, right to freedom of movement, freedom of religion, freedom to leave your country and to return to your one's own country, and also seek asylum from persecution. I repeat this word persecution. It's not prosecution, it's persecution. That's where a person is under a well-founded fear of being persecuted within the own one's country or own origin. We have known the case of Taslima Nasreen, who is from Bangladesh origin, and she has to seek refuge or protection in other countries because there is a well-founded fear of right to protection of life and personal liberty in one's own country of origin. Then there is protection of ethnic, linguistic, and religious minority. There is a right to participate in government through freely chosen representative by conducting genuine and periodic elections. The second set of rights, if I have to focus from in a developing country like India, I feel these rights are more relevant, more important, and therefore, all thanks to our apex court, the eminent judges like just late Justice V.R. Krishna Iyer, Justice P.N. Bhagwati, Justice D.A. Desai, who have given a meaning to fundamental rights and in categorical terms stated in several judgments that you can't segregate rights falling under part 3 of the constitution and part 4 of the constitution. These are interconnected rights because one set of rights cannot function without the other set of rights. So if I have to just think of my fundamental right to life, can I think of right to life without food, shelter, and clothing? Obviously, no. Can I think of right to life at the cost of my reputation? Can I think of my right to life, at the cost of my dignity, at the cost of my privacy? These are not even categorically mentioned within the Indian Constitution, but here is where we have our own Indian landmark judgments where these judges of eminence All three of them have passed away, but they have left a legacy, they have left a precedent where they have in categorical terms stated that these are crucial rights. Nevertheless, I'm sure as law students, we are told that the rights falling under Part 4 of the Constitution are not fundamental rights. There is no efficacious remedy, but the Supreme Court has given meaning to these rights, and but they are nevertheless fundamental in governance of the state. So the second set of rights under the UDHR are right to social security, right to join union, right to work, protection from unemployment. There's just favorable and reasonable working hours, periodic holidays with pay, right to leisure. There is a right to protection, social security for old age, sickness, disablement, or widowhood as such. Right to participate in cultural level activities and have a share in scientific advancements as such. Now, as I repeat what I have told, that you have series of people or categories of people who are still vulnerable. They are still falling under the category of marginalized groups or disadvantaged groups. I mean, being a human rights teacher, there is a full paper, an LLM as mandated by the UGC CDC curriculum as such, which speaks about the human rights of the disadvantaged group. So taking, for example, women, I'm sure as late as 2014, after the NALSA judgment, it's for the first time we realized that when we speak of gender, it's not just a man and a woman. Well, the Supreme Court has, for the very first time in the history of Indian judiciary, categorically stated that there is a third gender too, who are equally entitled to protection of fundamental rights, or what we term as human rights as such. It's been 10 years since 2014. The judgment was delivered in April 2014. It's been 10 years since then. The poor reality is that they are still not integrated as human beings within the society. There's no inclusiveness, be it in employment, be it in the society, be it at any place where they go. They're forced to resign from the jobs which were offered to them because of the inbuilt mindset and inbuilt discrimination against these categories. Now, when we speak of gender, we have known it's not just the general meaning as students of law we understand is man and women. The distinction lies not with the sex. Gender discrimination is quite different from sex discrimination. You find this user of this word sex within Article 15 and Article 16 of the Constitution. Sex is a biological distinction. Well, I'm born as a female and I'm a woman. A person may have been born as a male and therefore he's a man. But gender discrimination are socially structured differences. So, for example, against transgender, for example, against a women, well, the mindset is socially structured difference. You are a woman, so you should be, the expectations are, you should be soft spoken. It doesn't befit for you to be a woman with a loud voice. Well, you are a woman, so you should be very well dressed and, very decently dressed. Well, you are a woman, so the jobs which involve childbearing is a biological factor, so I won't go into it. But child rearing, taking care of elderly, leaving children to the school, getting them back, paying their fees, doing all the household chores, well, that's your job, and therefore you are the most fit person. Anything associated with the brain, these are the international accepted facts, that anything associated with the brain, it's the only male who are best suited for jobs. Anything associated with the body of a person, it's the women who are best suited for jobs. Last, and it's just about, and the matter is pending in the Supreme Court. I happen to be asked and requested for an article on hijab issue. Hijab is the half scarf, which is either voluntarily worn or which is used as an attire by the school going children or any person, a woman who may have, voluntarily opted for it for self protection. But the religion is used as a tool, as if it's a religious backed practice, and therefore it should be obeyed, or it must have been coercively, a woman may have been forced to, use hijab. In fact, one of my article on burkini, that was a internationally debated issue with regard to wearing a complete attire in a beach at France, and the matter went to the court, and finally even the court held that, well, a woman should not be fully covered, in the beaches as well. So the Indian perspective was sought for, and I will pass on the article to Rao sir, and it may well be circulated to the faculties and the students as well. Now, to choose one's attire, when we say right to life, it means and includes right to bodily integrity as well. Bodily integrity means and includes also right to choose attire as such. Now, in that case, would it mean that the human rights of a woman are grossly violated as such? This Burkini issue has raised an international concern, and therefore it's a matter for us at this juncture on the 10th of December 2024 to decide what attire should be worn. The hijab issue in the Supreme Court had a split decision by the two judges. One judge said that nothing doing, it's at a school level. If a girl child desires to wear a hijab, it's up to the gate of the school, and within the school, the hijab should be removed. Now, why is it that these practices operate only against a female child or a girl child, only against women? The matter whether it will be referred to the constitutional bench or whether it will be decided by the three-judge bench is a matter which we need to wait and watch as such. We have known of the various atrocities that take place against children, be it sexual abuse, be it, depriving a girl child of education, or be it depriving children generally when it comes to the matter of right to education. Significantly, I think as a law student, I need to also place my views that it's the constitution. It was just few days back we celebrated the Constitution Day, but look at the year when right to free and compulsory education for all children, at least till elementary or fundamental level, became or turned into a fundamental right by adding Article 21A within the Indian Constitution as late as December 2002, after the president's assent as such, and it took the shape of a law as late as 2004. Today, if we have to analyze and introspect, is right to compulsory, free and compulsory education for all children realized? I think that's a matter of concern, especially when we watch the rural areas where basic human rights are denied. There are children who are working as cultivators in agricultural farm. They go with their mothers to fetch drinking water miles and miles, and by the time they fetch a pot of water on their head in rural deserted areas as such, and when they are back home, well, it's evening. We know about child labor, which is most rampant in our country, though we have numerous legislations and amendments as such. We have known how there is an international trafficking racket, and India is equally guilty. That's not what I say. It's the UNICEF review report that there is cross border trafficking, or what we term as international trafficking, from Nepal to India, where they are the girls between the age group of 10 to 14 are trafficked into India, and they are forced to prostitution. Where are their human rights? And they are sold by their own parents for a meager amount, and they are all trafficked. The UNICEF review report reveals that they are trafficked all in active collusion and connivance with the border security forces and the police personnel as such, and they are forced to this. Why this age group is chosen from Nepal to India is because 10 to 14 years they are virgins, So there's no possibility of these young girls affected by HIV positive or AIDS. There's absolutely no possibility of, they having any knowledge, or they going to the police station, they complaining, and then eventually they become the regular prostitutes. As such, we have known that the laws within our country, the aim and objective is not to punish the one who may have accepted it as a voluntary, mode or way of earning their livelihood as such, and therefore they are not punished. Yes, soliciting customers at the public places is punishable. Agents or touts are punishable. They are the targets as such. But the UNICEF review report is very shocking. India has ratified major international human rights instruments. So, be it the two covenants, the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social, and Cultural Rights. Significantly, India has ratified both these covenants, but India is not a party to its two optional protocols. Now, in a very simple lay language, if I have to say, well, these optional protocols are addendum to the main covenant, and therefore, a country which ratifies the two covenants are also expected to ratify these optional protocols. So, when it comes to the very first covenant on civil and political rights, the two optional protocol provides for an individual complaint mechanism. Well, India says we don't give rights to our citizens to, have a redressal mechanism before the United Nations machinery as such. The second optional protocol deals with abolition of death sentence, the capital punishment, so-called capital punishment. India has not ratified that as well. In fact, the last today, the souvenir at the Governor House will be released, in which I have given a small article on capital punishment and why India needs to re-look into this issue when many of the developed countries have already abolished capital punishment or death penalty as such, and the ratio in those developed nations of crimes have fallen down drastically. Why do we not learn lessons from these developed nations and incorporate it within our laws? We have not ratified. The debates on euthanasia, when we speak of right to life as a crucial life, we don't have a legislation till date on euthanasia. It's the general guidelines of the Supreme Court which says active euthanasia, no way at all, because we uphold right to life of an individual. Passive euthanasia, yes, in exceptional case where, it is withdrawal of life support system or ventilator as such, that too subject to following certain guidelines as such. So if this be so, let me tell you that we need to look into the matter where we have the Transplantation of Human Organs Act. Let me place before our students, I am also one of the students, that it was Vishaka's case in 1997. We didn't have a law in its place, and the Supreme Court expressed shock and concern that there is no law which protects women from sexual harassment at workplace. It's high time now. Post Bawari Devi gang rape case, the Supreme Court expressed concern over having a legislation in its place, laying down certain guidelines protecting women at workplace. Again, when I make a mention of women, I need to place before you all now, right, today itself, that we 95% of our working population in India comprise of women and children who are working in unorganized sector. So how many laws are there to protect their human rights? How many laws are there to give them their rights to maternity benefit, minimum wages act, so on and so forth? That's a matter of great concern which we need to relook into, at least today when we are commemorating World Human Rights Day as such. So if this be so, where are our fundamental rights? Well, that's the children. We have known of the women. let's not be shy of what's transpiring in India. It is the United Nations report which says that women all across the globe are the victims of human rights violations. It's not just because I'm a woman, but I'm sure the UN report categorically mentions that women constitute half of the world population. They perform two-thirds of the total work hours. They receive only one-tenth of the world income, and they are owners of one stroke 100 of the world property. I think this figure itself is indicative of the fact maybe there are less atrocious acts against women in developed nations, because I had been to Sweden and I learned that women hold more than 50%. They had reached up to 50% then of parliamentary positions. As against that, in India, women are occupying only 10% of the parliamentary positions and only 6% of the union cabinet positions, which is indicative of fact how there are systematic and grave violations against few categories of people which are continuing and which are so persistent and which are so prevalent in our country, and which should be a great matter of concern for us, especially when we are discussing, speaking, debating, and learning about the human rights, at least on the World Human Rights Day. I just made a mention about custodial atrocities. Significantly, I must place before you all that India is a party to the two international covenants. India is a party to the Child Rights Convention. India is a party to the Women Centric Convention, which is CEDAW. That's the Convention on Elimination of All Forms of Discrimination Against Women. India is a party to that's the third convention, the Convention on Elimination of All Forms of Racial Discrimination. India is a party to majority of international instruments, but the matter of concern is significantly, and whilst at the international fora ratifying the convention, we very conveniently make certain declarations and reservations which are incompatible to the aim and object of the very basic convention. India has made reservation with regard to certain rights, which takes away human rights of women, children, so on and so forth. I will not go into that. When it comes to children, well, India says that, so what? I mean, the debates are, so what if a child supports, the family income as such, but then it can't be at the lieu and cost of, growth, the development and growth of physical and mental capability of a child. When we have ratified the Child Rights Convention, when the four major rights under the Child Rights Convention: protection, participation, development, and survival, India still has a long way to go. As students of law, we have studied that it was a very debatable, contentious issue to set up National Commission for Children. Now we do have state-wise as well, because the arguments were that we already have Women's Convention, we already have the National Human Rights Commission, high-powered commissions as such, that's adequate enough to take care of even children's rights, protection of children's rights as such. Now, the matter was not adequacy. Need was felt to have a separate high powered commission at the national level and at the state level. I remember as a student of law how many arguments were addressed when it came to establishment of these commissions at the state level. PILs filed by the PUCL, PUDR as such, when it comes to in the state of Maharashtra setting up a commission so far as protection of rights is concerned and protection of women's rights are concerned. The next issue, which is of serious, I think, thought provoking, and it should be thought provoking to all of us as well, is the custodial atrocities. We have all been victims of COVID-19 pandemic. We have known how migrant workers have suffered. We have learned lessons by COVID-19 pandemic. We have known how there were released by virtue of the Supreme Court virtual courts verdicts as such, how the prisoners were released, with a personal bond, because the condition and the situation in the jails and sub jails have been so atrocious against the people who are languishing in jail. It's the Indian Police Commission reports which states that 85% of the people who are in the jails and sub jails are just under trial prisoners. Their trials either have not commenced or have not ended up with a verdict of the court. So, if the presumption of innocence is to apply, we cannot address them as a convict. We cannot address them as an accused. We cannot term them as an offender as such. Why is it that they are suffering? Let me quote a judgment in the very opening paragraph of the Supreme Court in Rakesh Kaushik versus BL Vigilance as such, where the late Justice V.R. Krishna Iyer has narrated what is the condition in prisons. Very sarcastic remark in the opening paragraph of the judgment stating that his prison term in Tihar jail, which is the largest jail of the country, a postgraduate course in crime. Look at the words used by Justice V.R. Krishna. It's in the form of a question mark. Is prison term in Tihar jail a postgraduate course in crime? A person who is sent within the prison may have been a raw offender, not having known, but the conditions which are prevailing in prisons, overcrowding, lack of sanitation, poor medical facility, poor dietary arrangements, and of course, last but not the least, the custodial atrocities. There's no law in India which speaks of the first degree trial, second degree trial, third degree torturous method. The highest matter of concern which I wish to share with all of you is India till date. Till today, India is not a party to the Convention Against Torture of 1984. It's a matter of concern and shame for us if India has not ratified the torture convention. The complete nomenclature of the convention is Convention Against Torture and Other Cruel or Inhuman Degrading Treatment or Punishment of 1984. We have signed the convention in 1997 when the Vishaka judgment was given. But today, 10th of December 2024, we have still not ratified the torture convention, which should be a matter of concern for all of us. So there has to be a move at the individual level. There has to be a move at the organizational level. There has to be a move at the level of the government as well to introspect and think of its ratification in order to protect these persons who are victims of custodial atrocities. There are n number of judgments given by Justice V.R. Krishna Iyer, Justice P.N. Bhagwati, the famous Husainara Khatun case versus the Home Secretary State of Bihar, in which the court has also dwelled into the aspects which were not before the court. Look at the horrifying incident in the 1980s when women and children were arrested by the police without any complaint, without any charges against them. And the Supreme Court felt the necessity of suo motu, getting into the issue of right to speedy justice, right to fair trial, right to legal aid so far as these persons who are concerned as such. Interpretation of Article 39A of the Constitution, that's equal justice and free legal aid, thrusting an obligation on the state to provide free legal aid to the persons who are not even aware that they have a right to bail. So it's bail and not jail. That's what was used by, the eminent judges like Justice Krishna Iyer and Justice P. and Bhagwati. We have known, I'm sure when I lecture before the when I give certain public lectures, and my own students often debate into this issue, why so much crores of rupees was spent on Ajmal Kasab. Well, we have a provision within the Indian Constitution, Article 14, which says that the state shall not deny to any person equality before law and equal protection of law. So when the state shall not deny, shall is a mandatory word, it's not a discretionary word, to any person. Any person is not just Indian citizen. Well, a person may be an enemy outside, an alien enemy as well, who is within the territorial borders of India. You have the general principle under administrative law, that's audi alterum partem. A person cannot be condemned unheard even if there is ample evidence against a person. Right to fair trial be given to a person. And we have known, if we have to just look at the plain sentence of Article 21 of the Indian Constitution, which says that no person shall be deprived of his right to life and personal liberty except according to procedure established by law. Well, what is that procedure established by law? Tada and Pota were repealed, considering it as a very draconian law. But today as well, we have laws like the National Securities Act, the AFSPA, MISA Act, the Maharashtra Control of Organized Crimes Act, which are equally draconian, but yet those are prevailing. Significantly, the 2013 amendment of the CRPC, where there is compensation by the state for unlawful arrest and detention. The amount was raised just from rupees 100 to rupees 1000, which is highly inadequate. And now we have the three new law in its place. 1st of July 2024. I will not get into the nicety of the laws, and I'm told that the petitions are pending in the Supreme Court on the deciding the constitutional validity of these three laws, where there are people, I've heard people saying just the nomenclatures are changed, whereas the most of the 90 or 95% of the provisions are same. I will not go get into those debates and those laws, but I think at this juncture we need, and of course, as Justice V.R. Krishna Iyer has said, if we have to think of the welfare of people, there has to be decentralization of public interest litigation. It's only the High Courts and the Supreme Court, the High Court under Article 226 and the Supreme Court under Article 32 has got the power to entertain public interest litigation. There are cases, we have known of the epistolary jurisdiction, just an inland letter, just a newspaper report being converted into public interest litigation. We have known that the Supreme Court has relaxed the strict rule of locus standi, where a person has not necessarily be a victim of any violation, rights violation as such. We have known of the instances where the courts have sensitively dealt with these issues as such, but nevertheless, rights violations, you just open up today's newspaper, you will find at least 5 news which throws a light on persistent and continuing violations of human rights of a person. And therefore it's a matter of concern for all of us to re-look into and rethink. Let not just 10th of December be remembered as the World Human Rights Day. Let every day be remembered as a World Human Rights Day, because we have known our innocent people within the jails and sub jails, as late Justice V.R. Krishna had rightly said, that within the jail there are two categories of prisoners: class B prisoners and class C. Class B prisoners who are rich by bank robbery, and class C prisoners who are innocent, harmless citizens of India. And therefore, he said that to give a meaning to the constitutionally guaranteed rights as such, it is we, the lawyers who must take up, the public spirited persons who it's high time that we take up the cause, and the lawyers who must take up the cause. you know and therefore the basic function of a lawyer is not just to have or seek for a position of public importance as such, but it is to answer to the public when it comes as such. I have been a legal aid lawyer. When I was just introduced that for 12 long years, I practiced in the Bombay High Court as a central government pleader and as an advocate. When I had been initially as a junior, I was told and I was taught that you be a legal aid lawyer, where I didn't receive a single penny by way of fees. And one fine, when at the fag end, when I was to give up my profession, a lady came and gave me rupees 100, saying that I know you have worked very hard in the case. I mean, less spoken about the legal aid committees established in the High Court. Well, it is Justice P. N. Bhagwati and Krishna Iyer who said that when we speak of procedure established by law, a procedure which is the best procedure established by law, taking clues or taking the ratio of Menka Gandhi's judgment, a procedure which is just, fair, and reasonable is a procedure established by law. It's sharp 9:30 now. So I wish to just end up saying that human rights is a universal, as I'm sure we all read in the literature, that it's a universal right. It's not just recognized in India, Pakistan, Bangladesh, UK, USA, Scandinavian countries as such. It's a globally accepted. The Universal Declaration of Human Rights, as Pratibha ma'am mentioned, well, it says that these are the rights which are inherent, inalienable, and they are to be protected. So it's a declaration. So it's not a binding treaty as such. It's just a declaration, but nevertheless, it's a very, very forceful document, and it forms the pillar of all the rights. The two pillars in the form of civil and political rights and the economic, social, and cultural rights as such, which will which protects the general rights of every human being, not just in India, all across the globe. So, focusing from an Indian perspective, human rights of a beggar on the street and human rights of the President of India is the same. Let us think and let us. The United Nations changes its motto every year, so far as human rights are concerned. Let us think of the current theme, that's our rights, our future, and right now. So if we don't think right now, we should also push up the 7 parameters of the sustainable development goals, which in many of the parameters covers the crucial human rights which are to be realized by the year 2030. I feel and believe it's the bounden duty of we as citizens of India to push up India when we are progressing from various facets as such, to push up for the rights of a most ordinary person, of India as such, because we owe our duty, though there is no efficacious remedy for breach of fundamental duties as such. But believe and I feel that promoting even fundamental duties is a form where we can protect and promote the rights of the vulnerable groups of the society as such. So I'm very, very great. Thank you very much for a patient hearing. I'm very grateful to Rao sir for having thought of me, and Aparna ma'am. Of course, she was my student 24 years back in the Mumbai University, and I'm glad to see her as a faculty member in MP, a most prestigious college where I had been years back, to lecture on human rights. I think Principal Devlankar sir was the principal at that point of time. And I'll be glad to meet you all offline at some point of time, any seminars, so that we can meet each other Because though technology has its own charm, it has its disadvantages as well. There's a charm in meeting offline rather than online, but I'm very grateful to Pratibha ma'am, whom I've bothered numerous times calling up, and I'm grateful to the students who introduced and who are anchoring this today's seminar. My special regards to Rao sir, I hope he's here in the seminar, and my thanks to all of you all for a very patient hearing. Should there be any questions which I can address in a span of 5 minutes, because I'm just looking at the wall clock, in a span of 5 minutes, I'll be glad to answer the same. Thank you very much, all of you. Have a good day, a good Human Rights Day, good and blessed Human Rights Day. Yes.
Participants can type the question in the chat box so ma'am can answer the question. If there are any questions, so after that we can proceed for the presidential address.
So if there are no questions, I can presume that everyone who has been hearing me are endorsing my view. I think that's the presumption I can validly draw up. Yeah.
Thank you, ma'am, for your enlightening and thought-provoking address. Now, to add to today's discussion, I now invite our program president, respected Dr. C.M. Rao, sir, for presidential address. Over to you, sir.
It gives me immense pleasure to hear Dr. Rashmi Oja after a long period. So thank you very much, madam, for your insightful and thought-provoking address to our beloved students, where we have chosen a right resource person on the right day. So as I observed in your complete lecture, you covered almost all A to Z, right from principle to practice, what is happening in the society. And also we have drawn the attention of the people who are the budding lawyers, who are the students who are going into the profession, what to do and how they are going to make the justice to the people who are in need of the service. You have given example of your contribution to the profession, 12 years of profession where you supplied your services to the particular marginalized people to render your service of legal assistance. So as I observed from last 35 years, human rights means nothing that a human being is having a fish in mind and belly. That is selfish. When an individual or a group of persons or a politician or anyone in the humanity is having selfish, this is going to result in this particular human rights violation. Human rights violation. Even we are educators, the people also violating human rights of the students in somewhere where we are not going to be having any retrospectiveness in our mind what we are doing towards the student. And at the same time, it is the educators who are doing something for the protection of human rights till today. But the rulers, the executors, are the persons who are in power, not bothered about the human rights of individuals. So human dignity. So if you look into, if you're sitting in a house, in and around our neighborhood, how many of us knowing about the right to education under Article 21A, as you said? How many of you are making awareness as an individual, as a student? How many of you are going to make to avail this opportunity and the right to education? So is there any student benefited because of this particular thing? I came across several occasions. What to do, what not to do while you are traveling from one place to another, the drivers, the auto drivers, all these people. They never had an knowledge of right to education to make the children to study in a particular school where they cannot afford. This is the right thing. As you already told, this particular right, human rights, even we are advancing 77 years of independence, Azadi Ka Amrit Mahotsav, celebration of all these things will not happy unless we strive for the dignity of human beings. So on this particular Human Rights Day, so I thank the organizers for calling a right resource person to ignite the minds of budding lawyers. And I hope these people will work for the protection of human rights by making awareness in the neighborhood of their students. So thank you once again for organizers and also madam. Thank you very much.
Thank you, sir. Thank you.
Thank you, sir, for your inspiring words. Human rights are the foundation of equality, freedom, and dignity. They remind us that no matter where we come from, what we believe, or how we live, we are all entitled to respect and justice. Yet in today's world, the gap between principles and practice remains a challenge. Today, as we examine human rights in the modern world, let us remember that each of us plays a role in bridging this gap. Through empathy, advocacy, and accountability, we can turn ideals into realities. Let us pledge not just to speak of rights, but to act in ways that uplift humanity. For every step we take towards justice and equality, we come closer to a world where human rights are not just principles on paper, but practice in life. Together, let's build that world. With this, as we near the conclusion of this wonderful session, I now invite Ms. Yogesh Sonavne to deliver the vote of thanks. Over to you, Yogesh.
Good morning, everyone. My name is Yogesh Sonavne, and I am here to deliver vote of thanks. Honorable Chief Guest, respected Principal Sir, teachers, and my fellow students. It is my privilege to deliver the vote of thanks for today's important occasion of Human Rights Day. On behalf of Avishkar Research Club and Manikchand Pahade Law College, I would like to extend my special thanks to our respected Chief Guest, Dr. Rashmi Oja ma'am. Ma'am, for your thought-provoking and insightful lecture. Ma'am, your inspiring voice and passionate thoughts about human rights inspired us all. I would also thank our president of the program, Dr. C.M. Rao sir, for his gracious presence and presidential address. To our vice principal, More sir, IQAC coordinator, Aparna Kotapalle ma'am, Dr. Pratibha Girvane ma'am, and respected faculties who are present here and management, thank you for your tireless efforts in organizing this program. A special thanks to Sakshi Gore for such a good anchoring and Sakshi Chondiye for introduction of the guest. Once again, both of you, thank you for keeping the program engaging. A big thank you to my fellow students. Once again, thank you all for your presence and support. Let us continue to work together to promote human rights and dignity to all. Together, we can work towards building a world where everyone's rights are respected and upheld. Thank you.
Thank you, ma'am. Thank you so much.
Thank you, ma'am. Can I leave now?
Yes, ma'am. Thank you so
Thank
much.
you very much.
Thank you so much, with you, and we would be happy to invite you on physical mode in the college premises. Thank you, ma'am. Thank you once again.
Regards to Sir Rao sir also. Thank you, sir. Thank you.
Thank you very much, madam. We'll meet private offline once.
Sir.
Thank you, everyone, for your online presence and participation. Stay safe, stay inspired, and have a great day ahead. Thank you.